Joe and I wrote this book to tell the story of the great writ of habeas corpus in a way that it had not been told before. We wanted a book, a story about habeas that was accessible to experts and non-experts. So it's pretty short. It's not very, very wide. And at the same time, we wanted it to be comprehensive. We wanted to bridge those gaps between scholars who work primarily with criminal justice and scholars who work primarily with other sorts of detention, such as military detention and immigration detention. So we looked at all of the applications of habeas in civil commitment, in pretrial detention, and so forth. We wanted the book to be empirically based in the latest research, and we used the study, the 2007 study, and we have copies of it if anybody wants some, that I completed with scholars at the National Center for State Courts with the help of 12 hardworking, brilliant Vanderbilt law students back in 2006, and I'll be forever grateful to them for the study. And finally, we wanted this book to be forward-looking. We didn't want it to be a history of habeas. We didn't want it to be a description of habeas. We wanted to improve habeas. We're both pragmatists. We care about reform. We care about policy. So we made concrete, real suggestions to Congress about what to do. And each chapter has some recommendation for reform in it. When we looked at the pattern of habeas usage over the 2 centuries in all these different contexts, we saw something that occurred again and again. We saw that habeas provided a bridge whenever it was used. Whenever Congress and the President or the states decided it was more important to lock up people than to comply with federal law, habeas played a very important role. It protected individual liberty until alternative judicial review, some sort of alternative form of protecting and enforcing federal rights, took shape. And then that alternative form of judicial review could take over and habeas could recede. And we saw this over and over again. We relate many examples in the book. For example, with immigration detention, habeas was the only way to get a federal judge to look at incarceration for deportation. Throughout the crisis with the Chinese immigrants in the late 1800s, through the Red Scare in the early 1900s, and it took some time for Congress to come up with an alternative, but eventually we had the Immigration and Nationality Act, and appeals of these decisions could take over the role that habeas had played. Again and again, whenever the nation is threatened, the political branches may react by targeting those who are feared as dangerous with imprisonment. And again, the writ of habeas corpus has allowed the judicial branch to ensure that freedom is not lost. Habeas freed thousands of Chinese immigrants on the West Coast in the 1880s, thousands of Cuban refugees on the Florida coast a century later, 50,000 U.S. citizens of Japanese descent when they were interned during the World War II, and thousands of people who had been rounded up after 9/11 very recently and detained for deportation, used habeas to secure their freedom. So it's a bridge once again now in military detention. We see the Supreme Court holding in the Boumediene case that the Congress's attempt to deny access to Guantanamo prisoners was a violation of the suspension clause in the Constitution. Given the lack of procedural protections and the risk of error in the military proceedings that triggered detention and kept them there, the court held that the toothless appeal to the D.C. Circuit that Congress retained was not an adequate substitute for habeas. And so until Congress and the court can agree on an alternative, military commissions plus some sort of review, habeas courts are doing this job. So it's just another example of the same thing that habeas has done over and over. We argue that this core function of habeas is both temporary and structural. It prompts institutional change, the development of new alternative remedies, rather than correcting and deterring error on a case-by-case basis. And all of our recommendations in the book grow from this thesis. In Chapter 2, we argue that habeas must remain a flexible remedy for those situations where the federal government detains without conviction, because there'll inevitably be other crises where fear will rely on incarceration. And in what is the most controversial part of the book, we argue that habeas has already served this structural role in the context of reviewing state criminal cases. Its continued use as a routine appeal, case by case, is an abuse of this special, unique remedy. Sunday's op-ed in the New York Times addressed this point in particular, but very quickly we argue in the book that the Warren Court's expansion of habeas in the 60s was an appropriate use of this structural tool, because as after the Civil War, when the states were first encountering new federal law, the 13th and 14th Amendments, that they didn't want to follow, and Congress expanded habeas then. When the Warren Court expanded habeas to help states, encourage states to enforce federal rights, it served as a bridge. It protected the rights of state prisoners when there was no other remedy for state prisoners to seek enforcement of federal rights. At the time, in most states, state post-conviction proceedings either did not exist or were limited to jurisdictional errors, and appellate review in criminal cases wasn't functioning. There was no right to counsel on appeal yet until 1963, and many barriers to relief. But instead of habeas being a temporary stand-in, what happened was it became ensconced, an entitlement. It's permanent, and we think that's a mistake. We specifically recommend in the book that Congress should limit habeas review for state prisoners not on death row to one category of cases, and that is cases in which prisoners have strong new evidence of actual innocence. This is the one category of case where state court remedies are still not quite developed yet. It's the one category of case where federal law is clearly in flux. And it's the one category of case where both sides of the political spectrum can agree that the interest in finality is its weakest. Now, there are three reasons why we argue this, and I just want to cover those and then I'll sit down, and I'm anxious to hear what others have to say, including you all in the question and answer. We think it's important to stop using habeas in this way for three reasons. It doesn't work, it isn't necessary, and it's harmful. It doesn't work because such a small percentage of those convicted of non-capital crimes in this country will ever have access to habeas, and the success rate of those that do is so tiny that state judges can ignore habeas review. It doesn't affect their behavior in non-capital cases. They can ignore any risk that they would be reversed. And for reasons that we explain in the book, habeas review cannot be made into a meaningful remedy that would change that. We also think there are much better ways to enforce federal rights in state criminal justice. Instead of spending resources at the back end where they can't work, it would be much more effective to spend resources at the front end where they can do more for more defendants than habeas could ever do. The other, second, we say it's not necessary because habeas long ago accomplished what it was supposed to do. It transformed state criminal justice into a system that had post-conviction remedies where state judges assume and do enforce federal law as well as state law. And finally, we think that clinging to case-by-case habeas review of thousands and thousands of petitions that lead to relief so extremely rarely is harmful. It diverts the scarce resources of the federal courts and the states away from things that would be much more useful and helpful for the state criminal justice system. It's produced a generation of lawyers and judges who understandably view habeas cases as a waste of time, and it threatens to undermine public respect for the writ generally. So in sum, the writ of habeas corpus is an incredibly valuable, important tool for our democracy, and we'd like to keep it that way.
Hi, I'm going to talk from here.
Okay, and but I got to say one thing before you get going. I'm sorry, interrupted. Barry was the first one who introduced me to habeas corpus, and I don't know if he's sad about that at this point, but I'm very, very grateful that he came to speak with us today, and if he inspired me to care about post-conviction, and I'm thank you for that, Barry. I appreciate that.
We won't tell everybody how long ago that was. So Nancy came to the office that I'm using right before the program and said, I just want to say hello. And I said, I don't think I was supposed to see the bride before the wedding. Sorry, Tim, it was just a metaphor. But I mean that. It actually puts somebody who's here to review or talk about the book into a dilemma of sorts, because on the one hand, as an academic with integrity, I want to do justice to the book in terms of whatever I think. And on the other hand, not only Nancy but Joe are both old, dear friends. And so I need to be able to toe that line between candor about the book and respect for the hard work that they've done. And so I decided that there was a solution readily at hand, which is that along with the book's thrust to look at empiricism, I would use objective measures to figure out what it is I should tell you about the book. And in fact, I use two objective measures that are common for people that are reviewing books, particularly from the academy. So the first thing that I did was I took the book and I looked at how many pages it was. It's 247, which isn't huge, as Nancy points out, but it is about habeas corpus, so not so good. And then the next thing I did is what every academic in their right mind would do when confronted with a new book, which is that I decided to look and see how often I was cited in the book. Now that's tricky, you know. I've always thought publishers should just put a little grid in the back that sort of showed you, you know, who was cited and where, so you could go right to those places instead of having to sort of waste all your time looking through the footnotes. But I had the advantage of modern technology, and so I had an e-version of the book, and so all I had to do was use the find function, and it was 0. And so I can't say that I was favorably disposed to the book based on the objective criteria.
I deserve anything I get from this point on.
It's a wonderful book, and I want to say some things about why it's a wonderful book, though to do so would be, at some level, to repeat some things that Nancy just said. The preface to the book tells you what it wants to do, that it wants to be comprehensive, that it wants to be data-driven, that it wants to be reform-oriented. And unlike most books that I spend my time reading, it actually does all of the things that it tells you it's going to do, and I think it does them wonderfully. It's wonderfully written. For a book about habeas corpus, it's actually astonishing how readable that it is. But the most important thing about the book is that Nancy and Joe did something that's very remarkable and very rare in the world of ideas, which is that they, I often tell people the great article, the great book is the idea that everybody kind of knows, but nobody's written, because it's just there waiting to be grasped. And they grasped they explained the core function of habeas corpus. They connected the dots in a way that, despite my many years of caring about this issue and writing about this issue, I don't think I ever completely understood. And I think it's really a remarkable triumph in the book to just understand the way that habeas, which was this great writ, stretching back to the common law in England, is still and has served that function throughout American history, and I really applaud them for that. The other thing the book does, though, and Nancy and Joe are very candid and upfront about this, is that it serves as a basis for a debate. They wanted it to kick off a debate. They intended to be controversial, and I think it's going to do that no matter what, and it's a debate that I think we very much need to have in this country. And I don't agree with everything in the book. I'm not sure I disagree with things in the book so much as had reasons to question them. And so I want to talk about what those are. And most of it, Well, there's three generally. The one that I'm going to spend most of my time on is the most controversial part of the book, which is the idea that we eliminate habeas corpus largely for prisoners who are incarcerated as a function of the state criminal justice system, except in cases of innocence and changes of rules that are retroactive. I want to say something about the process of change in habeas corpus, because I actually think that their proposal's tricky in that regard. And in tension with itself. And then if we have any time, I'm going to talk about something I know nothing about, which is the review of sentence determinations in the prisons for people losing good faith credits and whatnot. Don't know much about it, but I do have something to say. So let's turn to the part of the book that I know something about, both from practical experience as a litigator and also as a scholar, which is the thing that's going to tick some people off about the book is their suggestion that we should largely eliminate habeas corpus for all of the prisoners who are in prison convicted by the state system, that federal judges shouldn't review those. And the core of their argument is that it's a very big haystack full of petitions, and the needles in the haystack are extremely rare and almost impossible to find, and so the entire endeavor just isn't worth the candle. I'm going to use a lot of metaphors here. And so I want to think about that for a minute and figure out whether they've proven their case. It looks superficially like they've proven their case, like there are lots and lots of petitions and it's very rare that there's relief granted, but I want to think through whether it adds up to what they think it adds up to. So first, let's talk about the haystack. So what Nancy and Joe show us is that what was barely a trickle of habeas corpus petitions in 1950 has grown to a flood in the current period. In 2001, it was over 20,000, and today it's around 18,000, as best as I could tell from drawing my lines on the graph. Of course, to tell you that there are 18,000 petitions as opposed to very few in 1950 doesn't tell you very much, as anyone knows whose parent told them that when they were kids, ice cream used to cost 10 cents, which is everything costs more. There's inflation in every regard, and so you have to sort of figure out how to control for that inflation. And Nancy and Joe do. So what they ultimately do is they tell us what's the rate of petitions per prisoner, or per thousands of prisoners or 10,000s of prisoners, because that's going to be the germane fact. It's not whether there are more petitions generally, but because as I think everyone in the room knows, we've dramatically expanded the prison population in this country, but how many petitions per groups of prisoners? And here the data is actually incredibly interesting. I mean, I had no clue what I was going to see, and I'm surprised by the figures, even haven't seen them. So in 1950, we'd get 40 petitions per 10,000 prisoners. 40 out of 10,000. By 1970s, which was, you'll forgive me, the heyday of habeas corpus, we were getting 500 petitions per 10,000 prisoners. And today, the number is about 150 habeas petitions per 10,000 prisoners. If I get my numbers wrong, try not to interrupt me and embarrass me here in front of all these people, okay? So when I look at those numbers, 40 out of 10,000, 500 out of 10,000, now down to about 150 out of 10,000, two things strike me. The first is prisoners are remarkably rational. So, you know, the reason that it hits its height in the early 1970s is because that's the peak of expansion of criminal procedure rights, and that's when people have the best chance of getting the get out of jail free card. And so they're filing a fair number of petitions. And then it all gets clamped down on, and the number of petitions drop to 150 per 10,000. The second thing, and related, is I don't know what the right number would be. I mean, I have no way of intrinsically knowing how many petitions per 10,000 prisoners would be the right amount of petitions per 10,000 prisoners. I don't know if it was 40 or 150 or 500. Standing alone to look at the haystack doesn't tell you very much. And they don't stop there. They go to the logical next place, as they say, but there aren't very many needles in that haystack. That out of that haystack of petitions being filed, there are very, very few of them that get granted. It's 0.4%, is that right?
Less than 0.4%.
Right, so less than 0.4% of the petitions get granted. And so that's what leads them to say that the endeavor is not worth the effort. But let's talk about the needles for just a second. So despite the small numbers, I'm still not sure I'm convinced. First, because of something they do in the book that I think is needn't have been, which is that they take the status quo for granted. In other words, they accept that the Supreme Court has not only substantially rolled back criminal procedure rights generally, but more importantly, has rolled back the availability of habeas, that Congress certainly in EDPA as a partner with the court has made it extremely difficult to get through habeas corpus. In fact, one of the things that I think is very important that they tell us in the book is most prisoners can't even file because they're out of jail before they can ever get to a federal court because of all the either roadblocks or not, depending upon how you think about it. And so I can't tell you what that number would be, the needle number would be, if I didn't accept the judgment of the court, both about substantive criminal procedure and about the availability and access to habeas. But I kind of need to know that. But more important, I think, is that even assuming all that was just how I normatively would think that it should be, that the law of criminal procedure and access to habeas was exactly how I think it should be, I also don't know if 0.4% is a bad number. Now, Nancy and Joe seem to think it's so few that the effort isn't worth it, but that ignores what political scientists would call anticipated reaction, or what the rest of you might just call deterrence, which is maybe the number's so low because there's habeas. If there wasn't habeas, then in fact the number would be much higher. The reason that we have laws and prison sentences to enforce them is not because we want to throw a bunch of people in prison, but because we think that by having those laws, people just won't engage in certain conduct. And certainly one of the theories of habeas is that it existed to get state courts to pay attention to federal constitutional guarantees. And one thing that Nancy's and Joe's numbers might be telling us is that it's all working really well. That because of the existence of habeas corpus, in fact, the state court system is paying careful attention to federal constitutional rights, and we have no idea what would happen if the federal courts stopped doing that. It would be like if we decided just to pull all the police off the streets and see what happened to crime. And by the way, those 2 points work together because one of the most important things that the Supreme Court did in the Teague case, and Congress wrote into law, was this notion that the federal courts won't overturn a decision of a state court on a federal constitutional issue unless the decision was wrong at the time it was rendered. So even though the law might have moved in the favor of the prisoner, that doesn't count. It's only did the state court toe the line at the time, the way the law was at the time. And so we would of course expect egregious ignoring a federal law to be very, very rare. The third thing that they do, in part as a response to that, is they say, well, but look, we should focus on the haystacks where there are lots of needles. And the haystack that they point us to correctly, I think at every level, is death cases. That death is different in many different ways, the consequences of a death sentence, the fraught nature of the trials that surround death sentences. And in fact, it is true that in a startlingly higher percentage of the cases, federal judges tend to find violations of constitutional rights in death cases. And they say that that's an example of a haystack where we should be paying close attention, and that we should save habeas for close cases like that. And I agree, it's fair enough, but I just want to point out something interesting in their data, which is because of the roadblocks and because of how difficult it is to ultimately get to a federal court and because of how long it is, as Nancy and Joe tell us, and again, interesting, not stuff I knew, 30 to 40% of the habeas petitioners in federal court are lifers. The people that make it to federal court, who are still incarcerated at that point, have committed the most serious offenses. And they also tend to be the people who didn't plead guilty, maybe because they had a reason not to plead guilty. And so if you think of sentences not as a cliff, there's death and it's different and then there's everything else, but it's a continuum from death sentences through life without parole through life to shorter terms of years, then in fact the distance between the cases that do get filed in habeas court that they think are worthy, the death cases, and the ones that get filed that they don't, often these very serious crimes, is much smaller. And there's at least reason to wonder whether in crimes where people are getting life without parole or life, in fact, I'd be curious about death and non-death states. And I'm also curious about pre and post Teague in terms of the grant rate. that these also might be cases where the situation was fraught and the crime was serious, and state officials might have been inclined to cut corners and not follow the rules, as sometimes they do. Though most of the times they do follow the rules, as they should. And if that's true, then in fact, the reason that we don't see so many needles in one of the haystacks and see lots of needles in the other isn't because the needles aren't really there in the other haystack, but we're just not looking carefully enough. That the quality of counsel in federal habeas death cases is much higher than the quality of counsel in ordinary federal habeas cases, and that people are looking much more closely for the needles, and that's why they're finding more. Now, all that said, am I sure Joe and Nancy are wrong about what we should do about prisoners through the state system? I'm not sure. They do have allowance for certain cases. I'm going to throw out one totally wacky, crazy idea as an alternative to their idea. I agree that it's a sorting problem, that what we need is a way to find the needles in the haystacks, and the way that we're going about it is to use a Yiddish word, meshuggah. It makes no sense at all. I actually think that probably the left and the right at some level are united in thinking that EDPA was a mistake, in the sense that we took the litigation of substantive criminal claims and we've done nothing but replace it with this bizarre litigation of procedural defaults and exhaustion and things that it's impossible to teach anybody in the classroom. And that wasn't a step in the right direction. But you know, one of the points that just oozes out of the book as you read it is habeas is a lottery. You know, it's like, I have a friend who's an economist who I asked her once to buy me a Powerball ticket from Iowa when you couldn't get them in New York. And she said, well, why don't you just send my husband and I to lunch? Because the chance of you winning this is just about the same, and we could have lunch. And I said, yeah, but I still buy lottery tickets every now and then. And so you never know, somebody wins, right? And so what if we just turn habeas into a lottery, or maybe even better, an auction, right? And so, you know, we raised the filing prices, right? Or we made it a contest to be able to pay the price. And you're thinking, well, that can't possibly be right, because then rich people who are in prison, and there aren't a lot of them, are going to, you know, have greater access to habeas than everybody else. And that's true, though it's still probably better than nobody getting it. But you know, there's this thing called the internet. It's remarkable. And so what we could do is we could actually have contests where people could kind of float up their habeas petitions, and people could go in and donate, you know, a few pennies or $1 or whatever, and they could raise the stakes so that we could have this kind of popular, like, TripAdvisor way of figuring out whether people should get out of jail or not, and they could afford the filing fees. And anyway, I'll stop. It's not crazy, though, I actually think. So I want to go to, and I'm getting to the end, but I want to talk about what I actually view as the other really tricky thing about the book. And it's not, I'm not sure Nancy and Joe are going to disagree with me about this, but I think it's a real problem. So Nancy and Joe make the case that one of the gems of habeas is that it's been a flexible remedy, and that it's been able to adapt to circumstances, that it was called in a surface at these times when it was really needed to serve as a bridge, that was its core function. And yet Nancy and Joe, you know, perhaps unwittingly suggest that what we ought to do for state habeas is we ought to have Congress pass a statute that restricts it to cases in which there's a claim of innocence, or cases in which there's a retroactive federal rule. But you know, the problem is that, so back in the old days when I was writing about habeas, before many of you were born, the way it worked was that the court would alter habeas gradually, and every now and then Congress would come in and would codify what the court had done. And then I think EDPA was a change in a sense, because even though I think it's arguable that Congress actually did nothing other than adopt what the court had already suggested, I at least have an argument why that's the case, having written it into the statute, it's impossible to get around it. It's like the least flexible remedy we have going now. It's not entirely clear, and there's lots of litigation about it, but it's not flexible at all. And I think there's this real tension between Congress stepping in and legislating and the writ remaining flexible. So I can think of for example, a few issues in the state criminal justice system where we might need habeas, where under their proposal, we won't get it just because by locking in statutorily, we won't be able to spot and deal with these problems. So one, by the way, is I'm curious about geographic dispersity of habeas because I'm guessing that the criminal justice systems in every state are not equal. Certainly the provision of counsel, and I think counsel is one of the big coming issues. The quality of counsel is not equal in all the states. I think the drugs is going to become a very big issue in this country. I certainly hope it is, and one that actually unites the left and the right in terms of what I think is a senseless toll financially and in many other ways that we've exacted through what is a completely failed war on drugs. There's pervasive racism in the criminal justice system. It's no secret to anybody that looks at any profiling data. And it's hard to know how those may become issues where there's actually a left-right agreement that we need to do something, but it's not, but there's still need a bridge, and it's not clear. And not only just a bridge, by the way, but one of the great things habeas corpus does is it focuses attention. It creates controversy. People start to fight about things, talk about things, notice things, and I'm not sure that there's always a way for that stuff to happen. And indeed, I know exactly what's going to happen to your guys' proposal, which is that they basically proposed something that superficially I might be quickly willing to buy into, which is they said, we're not suggesting just that we cut back on habeas, which is a lot of looking through the haystack for very many needles, but we want to trade. And the trade we want is cut back habeas, but put the money into improving the quality of counsel in state criminal cases. And I applaud that. I think, you know, a back-end solution like habeas is nuts when you could have a front-end solution, when you can have better lawyers in the first place and not have the problems. And I think every one of us up here, if we're honest with ourselves, knows that in certain pockets of certain places at certain times, there are appalling problems with affording counsel in criminal cases. But the world being what it is, they're going to get half a loaf. They're going to get the restrictions on habeas, and they are not going to get the relief for defender services. And that, I think, if it happens, will be a shame. Let me just say one last thing, and I will subside. So I don't know much about good time credits, even though I've always thought that was a funny name for them, right? Good time credits. I'm having such a good time. I'm getting out early. The story in that chapter, and again, it's an area of the law I don't know much about, is that there's a lot of habeas litigation about internal prison discipline rules and how they affect the sentences that people are actually serving. And the habeas is a bonkers way to deal with that, and there maybe should be some administrative procedures. And I don't necessarily disagree with that because I don't know enough to disagree. But it does strike me that in a sense, that might be where one of these bridge problems is happening that we're not noticing it happen, which is, you know, what's happened in this country? We moved to determinate sentencing and we ratcheted up sentences because there was just this political war to see who could be tougher on time, and we've locked people up for insane lengths of time. Insane meaning we're wasting phenomenal amounts of our money because people who are, 63 years old aren't going to go out and be petty criminals, but they're still locked up. And this is no secret either, because with the states all in terrible financial trouble, the first thing they're doing is trying to figure out how to cut back their prison populations. But so what you have is these people that were locked away for really long periods of time, so the amount of time you're locked away for matters. And then you have this enormous discretion in petty officials to figure out whether you're going to get good time credit and things like that. And it could be that that actually is a flashpoint. That's where we're going to have the focal point for, did the prison sentence lengths make any sense? And you may be closing the door to that discussion happening. Those are the critical things, but I reiterate, it was an incredibly interesting read. It provoked a lot of thought in me. It's beautifully written by the book. Judge?
Well, I follow the academic, and as a judge, where we impose time limits, you can expect that I will obey mine. Although I'm concerned about this whole thing about introducing Nancy to habeas. It sounds like it was almost like a blind date. I'm honored to have to offer a few words of praise of Professor King's latest work, her book with Joe Hoffman, Habeas for the 21st Century. Professor King's distinguished and important scholarship in the field of criminal law, especially her empirical analysis, has advanced our understanding of criminal investigation and procedure, the role of juries, sentencing, and the collateral review of convictions. But her new book does something more. It offers us a path for bold reform. I want to say two things this afternoon. First, I want to explain why the book should be welcomed by all who are interested in the subject of habeas. Second, as you might expect with a subject as controversial as habeas, I have a few quibbles with some of the arguments in the book, but I want to explain why my disagreements should be regarded as quibbles that do not detract from the main thrust and recommendations of Professors King and Hoffman. There are a few aspects of this book that I submit are especially welcome. First, the book should be appreciated for two features that are hard to combine. I promise we didn't get together beforehand to share notes. Those two features are brevity and comprehensiveness. It is elegantly written, free of jargon, to allow the reader to understand in fewer than 200 pages of text. Of course, the academic went to the footnotes. Both the historical, you'll notice if you read my opinions, I never write footnotes. Both the historical development of the writ of habeas corpus and its current challenges. These qualities should enable the authors to reach a wide audience of legislators, policymakers, judges, practitioners, scholars, and students. I intend to add the book to a list of recommended readings for my prospective law clerks to allow them after graduation, but before they begin their clerkships, to read beyond their case books from law school and better appreciate an area they will confront on a regular basis. Second, as we have come to expect from Professor King, the book is rooted in both empirical analysis and a balanced perspective. The book offers a view that is shaped by the reality of habeas today, both in its practice and in its judicially defined scope. Third, the book proposes well-defined and practical reforms that would dramatically alter habeas review for the better, in my judgment. As someone who has labored in the vineyard of federal habeas, first for 7 years as a state attorney general and then for another 7 years and counting as a federal circuit judge, I can attest to the fact that for most state prisoners, the Great Writ is an illusory remedy. And for both state governments and federal courts, it is both expensive and burdensome. Professors King and Hoffman powerfully present their empirical analysis that the Great Writ is no longer necessary for the review of non-capital state convictions, and they explain why, in their view, the still unsettled nature of capital sentencing requires different treatment. To be sure, grants of relief in capital cases are far more frequent than in non-capital cases, but a substantial number of capital petitions, in my experience, are neither meritorious nor difficult, which suggests that Professors King and Hoffman are also wise not to suggest that the habeas reforms of 1996 should be repealed altogether in capital cases. They instead offer practical ideas about improving the administration of these cases and guarding against the execution of an innocent person. As you might expect in a book about this subject, there are aspects of habeas for the 21st century that are controversial, but they do not detract from the sound analysis and wise reforms proposed by the authors. One controversy pertains to the alleged need for habeas review of executive detentions of aliens held outside the United States as part of the War on Terror. The book begins with an almost celebratory treatment of the recent decision of the Supreme Court in Boumediene versus Bush, which held that the writ of habeas corpus had been suspended unconstitutionally in the case of an alien captured abroad and held at Guantanamo Bay. Not everyone agrees with the author's assessment that this 5-4 decision was, quote, a triumph of individual liberty and the rule of law. This statement in the early pages of the book might jar some conservative readers who still view the Boumediene decision with skepticism and perhaps even consternation or dismay. But the main point of the authors about executive detention is surely right and should be widely accepted. That is, that modern forms of executive detention, whether of immigrants, sex offenders, or even enemy combatants who are often either citizens or persons found in the United States, pose a constantly changing threat to liberty that should remain the core concern of the Great Writ. Another controversy pertains to the application of the suspension clause to the collateral review of state convictions. Professors King and Hoffman argue that Congress should essentially eliminate the federal review of state convictions in non-capital cases, save for cases that involve either truly new and fundamental rules of constitutional law or federal violations that, in the light of newly discovered evidence, establish that the petitioner is likely actually innocent. Their proposed legislative reform calls to mind the legendary Judge Henry Friendly's influential article published in 1970 in the University of Chicago Law Review, in which he argued that habeas review should be about colorable showings of innocence. Professors King and Hoffman contend that following the adoption of their proposed legislative reform, the Supreme Court should then employ the suspension clause as a safeguard against new forms of state abuse. The Supreme Court has never held, of course, that the suspension clause applies to the review of state convictions, and there are substantial problems with that interpretation. Professors King and Hoffman rely upon Jordan Steiker's article published in 1994 in the Michigan Law Review, which contended that the 14th Amendment incorporated the privilege of habeas corpus. But that amendment forbids state violations of civil rights and says nothing about a federal obligation to make the Great Writ available for the review of state convictions. Professors King and Hoffman also contend that state systems for the collateral review of convictions now provide an effective substitute for the writ, but it is unclear to me how a state system can satisfy a federal obligation of habeas review if the federal government is in fact obliged by the suspension clause to provide that review. Although Professors King and Hoffman make the application of the suspension clause a central part of their argument for reform, the problems with interpreting the suspension clause to require the federal review of state convictions should not detract, in my judgment, from the professor's core thesis. Presumably, if the professor's proposed reform were enacted, the Supreme Court would still be able to exercise its power to entertain original writs and enlist the aid of federal district courts in the development of records for those proceedings. Moreover, if one or more states were to engage in new abuses that require different forms of federal oversight, there's every reason to believe that Congress would exercise its authority to expand the availability of the writ to curtail those abuses. This book recounts how Congress historically has exercised its power wisely to make the Great Writ flexible and available as a safeguard for freedom. Congress saw that need in 1867 when it first provided for the federal review of state convictions, and Congress saw the need for reform in 1996 when it enacted the Anti-Terrorism and Effective Death Penalty Act. If Professors King and Hoffman are able to persuade Congress to adopt their proposed reform, then there will be good reason to believe that they or others like them can persuade Congress in the future to reform habeas again to curtail new abuses of state power. I will end by sharing a brief personal story about reading this fine new book. I was hearing oral arguments last week in Miami and was able to get away from the courthouse a little early so that I could finish reading the last chapters of this book on, of all places, South Beach. I was reading the book by the pool at my hotel when I heard 3 law students express their joy of being away from class for a few days. I asked where they were students, and they responded that they were second-year students at Georgetown, certainly not Vanderbilt. Then they saw what I was reading, shrieked in horror, and asked if I was a lawyer. When I responded that I was a federal judge, one of the students, presumably thinking that a trip to Miami Beach is not a bad fringe benefit, immediately said, "Hire me." I realized that the market for young lawyers is tough these days, but even so, I was startled by this impromptu application. I briefly explained my application process for clerkships and quickly returned to reading the book in the hope that I would avoid any more awkward moments. The moral of the story, I suppose, is an optimistic one, that you never know what will happen when you read this book. I want to congratulate Professors King and Hoffman. I hope your book is read from the beaches of Miami to the halls of Congress. I want to thank you for allowing me an opportunity to read an early edition and for asking me to be a part of this celebration.
Well, I've got two challenges now. One is that this is the point at which we go off script. I'll be speaking off the cuff. And secondly, I think I have about 3.5 minutes, 3 minutes and 45 seconds to try to get us out of here. Let me start by thanking both Barry and Judge Pryor. Barry, I am going to pin you down on this. You know, we've known each other for more than 25 years, since the time that I reported to clerk for the same wonderful 11th Circuit judge, Judge Phyllis Kravich in Savannah, whom you had clerked for just, I think, 2 years earlier. So, unfortunately, now they all know how old we are. By the way, we thought about the citation thing, but we figured we'd give you a really good intro if we, you know, didn't include you. Just a joke. Just a joke. Judge Pryor, we've actually personally met much more recently, but I'm just as happy to see you here as well. And you've given us a great new line for the press to build a book as a great beach read. I wouldn't have thought of that. We never thought of that, but we'll certainly pass it along to the press. The comments are just absolutely wonderful, and thank you both. The comments raised empirical questions. Of course, that's where we live, right? The whole project was meant to be data-driven. Nancy's work on the study back in '06 and culminating in the '07 publication was what started the whole project. You know, Nancy basically called me and said, I've got this great data. Would you like to work with me and figure out what it all means and you know, where it goes? And that's where it started. So empirical questions are exactly what we want to hear. We want to hear normative ones too, but the empirical questions are key. Things like you know, the number of petitions in absolute terms versus the petition per prisoner rate, this whole continuum of death and life and term of years. These are great empirical questions that I hope we'll have a chance to explore in coming years. I thank you also for both of you for the insights. Well, actually, let me talk about candor first. I want to say one thing about what Barry said. I want to thank you for your candor, both of you. I want to particularly thank Barry for being the first person I've met thus far, including the many thousands of people who've been writing me emails since the op-ed piece appeared last Sunday. Not all of them happy, but you know, Barry, you're the first person I know who's actually defended the proposition that that 0.4% grant rate might just be right. You know, there's not too much, not too little. It might actually be just right. And that's, you know, that's a proposition I think most people wouldn't take, but I appreciate that, and we're going to have to think more about that. As far as the insights, let me just mention a couple of them, and then we'll go to whatever time you want to have, Chris, for questions, if any, and get out of here. You know, I think the insight about, you know, what it is that will get people most upset in this book, which is the proposal that was in the op-ed. You know, the New York Times probably wouldn't have published it if we hadn't led with the very most controversial thing in the book. And, you know, it certainly does really strike a chord with many people and become a very emotional subject. And I completely get that. You know, for convicted state prisoners and those who care about them and their lawyers, habeas corpus represents a vision of justice on the horizon. Maybe you'll never get there. Maybe you'll never touch it, but it's always out there. And it's, you know, after years of feeling like you've been victimized by the perceived indignities and injustices of a criminal justice system, habeas is that one final hope of justice. And in that sense, it is a lot like a lottery ticket. it isn't whether you win or not, it's that hope. It's something to hope for. And I think that, part of what we've seen as a reaction to the book is, when you tell people, the odds of winning on that lottery ticket are like this big, except if you're in a capital case or in one of these other scenarios, that predictably and perhaps even justifiably gets people angry. The other point I want to talk about is this whole point about the process, and it's a great insight. It's the kind of thing I would come to expect from a person like Barry Friedman. Brilliant insight. It is a tough situation, and we don't have time here to go into it in great detail. And Judge Pryor, you made exactly the same point, coming maybe from the other side. It's about the suspension clause. This is a complicated subject, and it is the place in the book, I think, where Nancy and I, in a sense, are the most out on a limb in terms of making statements and normative claims that are based on not much, because the Supreme Court, through its history, hasn't done that much with the suspension clause. We don't have a well-developed, body of jurisprudence around the suspension clause. So, Nancy and I have done a fair amount of extrapolating, to be fair, from Boumediene and a couple of other cases that the Supreme Court has decided. And what we came up with is our view, again, part of that big picture that we're trying to describe in the book of the role of habeas in structural and institutional terms. Our view is that the suspension clause actually is about ensuring that the ultimate power over habeas always stays with the Supreme Court, no matter what Congress and the President might try to do otherwise. So, what that means is, in a sense, that, the suspension clause, there's been this whole debate about, was there any habeas even at the time the suspension clause first appeared in the Constitution? That was before the first Judiciary Act. It was at a time when there was just the Supreme Court. There weren't even any lower federal courts. That's where this whole original writ of habeas concept starts. We would say it's an inherent, if I say this wrong, Nancy, please correct me, but I think we would say it's an inherent aspect of the federal judicial power, and that the suspension clause kind of expresses that, and it means that at the end of the day, the Supreme Court retains the power to kind of keep tabs on this. And while I don't disagree that Congress could perhaps do the job as well, in fact, part of our whole idea is that Congress does well when it engages the court in a conversation about this, as we suggest that they should in the context of state non-capital criminal cases. Congress is free to make suggestions to the court. At the end of the day, the court always retains the power to make the final call. I think I'll just stop there. It was really wonderful. I appreciate all the comments and look forward to whatever further time we have.
Yeah, I promised a question and answer period, so we're going to have